What's up, everybody? This is Made for Entrepreneurship on Clubhouse with Shontavia Johnson, and I'm excited about this new series. So this quick podcast will be the high points of the different conversations I'll be having on Clubhouse around entrepreneurship. And it's specifically geared toward Black and brown women who are working full time, who want to start businesses so that they can make more income and impact. And the podcast today will be about answering your intellectual property and small business questions. I wanted to give you a quick overview of the different things we'll be discussing as it relates to this topic. So, in this particular conversation, I really want to just hit the high points about what it means to have intellectual property as a new entrepreneur or a person who's getting ready to start their brand or start their business, and then the things you need to do as a new business owner to make sure you're starting the right way. So the first thing with your intellectual property is use the right language. And this is something that's actually pretty common for people to get wrong, where, they see like the term trademark or copyright or patent, and they're using it, but maybe not necessarily using it in the right way. And there are a couple of reasons I want you to use the words in the right way. So the first is so that you just know what you're talking about. But the second, which I think is really the most important, is when you're out creating all these different things, inventing things, creating brands or creating content or building your email list or this or that, you need to know what things are protectable. And not only that, when you reach out to a lawyer or you're working with legal counsel or a law firm, you want to be able to explain to them what you have so that they can best represent you. So I want to just make sure you understand what the terms mean and where you can use them in your business and where you can start looking for the intellectual property you have in your business. So the first is with trademarks. Trademarks really protect and relate to the way your business connects with others, and not just with others, but with potential customers and existing customers, and the way you are distinguishing yourself in the market for those customers. So the legal term, and it's got a little jargon in it, but the legal term really is that you have a designation. So that might be a word, a phrase, a color, a sound. Designation is this really broad term, but you're using this designation in some way that distinguishes you in the market from everybody else. And the thing that's really cool about trademark law is that this can apply to everything. So most people think about their trademarks as words and logos and maybe colors sometimes, but trademarks can be just about anything. So the way Lamborghini doors open with that vertical motion, that is a trademark. Or hand gestures. So Alpha Kappa Alpha Sorority Incorporated, the pinky hand symbol, that is a registered trademark. Now I'm a member of Delta Sigma Theta Sorority, but game recognized game, and the AKAs really have an on-point trademark strategy. Other things that can be trademarks are things like songs. So if you always play the same music behind your videos on YouTube or on Instagram or whatever, those things can be considered trademarks. And people don't typically think of music as being trademarkable, but it can be. Anything you're using to distinguish yourself in the market so that your customers know who you are, potential customers know who you are, and you're separating yourself from other people in your industry or field, that is what trademarks protect. Second, with copyrights. So I'm not going to get into all the details here, but I want to make sure we're just ground setting what the right language is. So trademarks, again, the way your business connects with others, you're distinguishing yourself in the market from other people. Second is copyrights. And copyrights is the way you protect your creative works. It don't have anything to do with your customers, with other people, or anything. It's your creative work that you are coming up with out of your head. Now, the legal definition of a copyright is an original work of authorship fixed in a tangible medium of expression such that it can be perceived for more than a transitory duration. But basically what that means is your work has to be original, meaning you haven't copied it from somebody else. It's got to be something called a work of authorship, which is a legal term, but basically the law just says here are the things that are works of authorship that you can get a copyright for. So that will be things like music, books, podcast episodes, artwork, architectural designs, choreography. There's a whole long list of things that meet that term of work of authorship. And then it has to be fixed, meaning we have to be able to see it for more than a moment. So like blowing a bubble, the bubble is not copyrightable. But if you post something on Instagram or Facebook or Twitter or whatever, that is tangible and technically might be considered copyrightable depending on what it is. So when you use the term copyright, you're really talking about the way you protect your creative work. And the thing that really is fascinating about copyrights is if I'm sitting in if I'm sitting in California and you're sitting in Alaska and we're writing poetry and we come up with the exact same poem, we both could have a protectable copyright because originality just means you haven't copied it from somebody else. So copyright law is really actually pretty flexible. And the other way that it's flexible is you can add other things to that definition of work of authorship. So like the law was written before the internet was created, but things that are protectable include like websites and apps and software. So you can argue that things that are new that maybe didn't exist when copyright law was created can fit within that definition of work of authorship. So at any rate, copyright law really is the way you protect your creative works, those original works of authorship that are fixed. Then third, patents. Patents protect your new inventions. So an invention has to be new, useful, non-obvious, and something called statutory subject matter. So the same way with copyrights, where the law says, here's a long list of what is a work of authorship, with patents, the law also says, here's a list of what falls within this term, statutory subject matter. And that's things like machines, like articles of manufacture, which is basically like mechanical stuff. There's a list that says, here's what is protectable. And the thing that you should really note about patents, which is different from copyrights and trademarks and even trade secrets, is that to get a patent, you actually have to file an application with, in the United States at least, the Patent and Trademark Office. You can get a copyright without ever filing an application in the Copyright Office. You can own a trademark without ever filing anything in the Trademark Office. There are benefits to doing those things, to filing those applications, but you don't have to. But to get a patent, you actually have to file an application with the Patent and Trademark Office. And then finally, trade secrets. So trade secrets protect the things that are valuable to your business through secrecy. So the dope thing about trade secrets is they are protectable because they are secret. So these are things that you're not giving up freely, you're not telling people about, and that makes them different from really trademarks, copyrights, and patents. So trademarks, by definition, like other people have to see them and make some type of connection between your trademark and your business. Copyrights, you actually have to create something that's fixed in a tangible medium, so something that we can actually see and people can perceive for more than a transitory duration, more than a moment. And then patents, you actually have to tell the patent office, here's my invention, and you have to explain to them exactly how to make it. Trade secrets, though, are almost the exact opposite. They're valuable because you don't tell anybody. So like the recipe for Coca-Cola or Kentucky Fried Chicken, or the way that, the Thomas brand puts nooks and crannies in their what are they called? In the bread that they make. So trade secrets are valuable because they are secretive. Now, where does that make a difference for entrepreneurs? It makes a difference, especially for people who are doing business online, your customer list. So whoever's buying from you, that is a trade secret protectable piece of intellectual property. Your email list. So your email list, everybody knows like the big value in your business is your email list, the people you're marketing to, or your text list, whoever you're texting. So those things are secret. And they derive value through being secret. So if you have things like that, things that are valuable to your business. They give you an edge in the marketplace. You might have something that is that could potentially be protected by a trade secret, which means you might think about taking some steps, like having your employees and your contractors sign NDAs, sign non-disclosure agreements or confidentiality agreements. So I wanted to do that quick overview on what it means to just use the right language. And then the other piece of this that I'll be talking about on Clubhouse is take the right business steps. And people, look at business and think, oh, it's so complicated to get started. I need to this, I need to that. But the way I teach starting a business, at least in my program, the Brand+Business Academy, is don't make it complicated. So let's do the basics. Yes, business can get complicated, but your goal is to get started. Don't get complicated, just get started. So I wanted to just explain really quickly what I mean by just get started. I think if you're going to get started, these are the things you need to do. The first thing is choose a name that doesn't get you sued. And this is a step that I think a lot of people skip right over. They Google a name. They say, oh, I don't see this name anywhere. Nobody's doing anything with it, this or that. So I'm going to roll with this name. And that can be somewhat dangerous if you don't do your due diligence. So the first thing I want you to do is choose a name that doesn't get you sued. And here's just some suggestions for how you do that. The first thing is, yes, Google the name, but don't stop there. Set Google alerts. So if you have 3 or 4 different options that you might be thinking about, set Google alerts so that you can see. Maybe you didn't find anything today, but next week there's an article in the New York Times about a business with the name that you want to use or whatever. So don't just set Google alerts, or don't just Google the name, but set Google alerts. The other thing you can do is search your Secretary of State's office. So most, if not all states, don't allow 2 businesses to have the same name. So you want to check your Secretary of State's registry or database to see what are the names people have already chosen. Because if that name exists and you want to use it, and then you go to get an LLC or get a corporation or a nonprofit or whatever, you might be stopped by your Secretary of State's office. So that's the other thing you can do. And then the next thing, or really one of the last things you can do, is consider trademarks. And you can do that by going to uspto.gov, at least to start, and searching the TESS database, the test database. It's the trademark search database. Just do a basic search and see if the name is registered. Now, again, if the name is registered, that doesn't necessarily mean you can't use it, but these are just your early due diligence steps that are free that you can take to figure out whether or not choosing a name is going to cause you some headaches later. But the last thing you can do, and the thing I think is most important as it relates to this trademark point, is reach out to a trademark lawyer, not a real estate lawyer, not somebody your girlfriend or your homeboy or your grandma knows who is not actually practicing that type of law, but a person who does this day in and day out. And sometimes those people will talk to you for free or do an initial consultation for free. And you want to go to them so they can give you some game about whether or not the research you've already done is sufficient. And if it's not, how they might be able to help you make sure you choose a name that doesn't get you sued. So why do I think you need to go through and take all these steps? The main thing is you don't want to get too far down the path. You spent money on your website, on your branding. You got t-shirts, you got business cards. Then somebody comes along and says, hold up, wait a minute. I own that name as a trademark and you have to stop using it. Then you have to start all the way over from the very beginning after you've put a bunch of money and time and energy into your business name. So I think choosing a name that doesn't get you sued is critically important. Second thing, register your business. Now, you can ride dirty. You can go out tomorrow, start a business, start taking money in exchange for whatever you're doing, but you are going to leave yourself exposed to potential liability if something goes wrong. And all kinds of things can go wrong. So my thought is always, if you can register a formal business with your Secretary of State's office, do it. So LLC, corporation, nonprofit, make sure you do that. Don't rely on being a sole proprietor or a DBA if there's any chance on God's green earth that something could go wrong in your business, because that business is going to protect you from liability. And what that means is if somebody gets hurt, if somebody's angry, if somebody feels like you've done them wrong and they sue you and you lose, if you don't have some type of corporate or business protection around you, if you don't have money to pay, like whatever judgment is against you in court, they can get your private bank accounts. They can get any of your assets that you own to satisfy that judgment in court. So registering your business is just good business. And I know it can be a little expensive, especially for those of you who live in states like California or New York or other states where there are a few more the requirements and hoops you have to jump through, but it is worth it to register your business. Then you need to get a taxEIN number. And that's something you can do for free at irs.gov. I know there are services that will do it for you for, a few $100s or $100. But literally, it takes about 10 or 15 minutes. And I think you should at least give it a try. Go to the website and see if it's something you can do before hiring somebody else to do it for you. Then after you take those steps, go get a business bank account. The word of the day is commingling, and you do not want to commingle your personal funds and your business funds because there are all types of business and tax implications when you do that. So getting a business bank account is so smart for so many different reasons. Go get yourself a business bank account and don't put your business money into your personal account and vice versa. And along those same lines, talk to an accountant. So this is a place where I made a lot of missteps with my first 2 businesses. I didn't talk to an accountant until it was way too late. And to be honest, there's still some things I am untangling because of mistakes I made years ago that I just didn't even know I was making until much later. But talk to an accountant about how you can set up your financial systems so that you're taking all the steps you need to take. And this is, I've made it point number 5, but it really is like an asterisk. But depending on the type of business you are starting, you might need some additional registrations and licenses from your state. So like, I'm a lawyer. I need to be licensed in the state where I'm practicing or have like some way to connect with licensed lawyers in a state. If I do hair, I've got to have a certain type of license to do hair. So make sure for your specific type of business, if you have a restaurant and you are serving liquor, you need a liquor license. There are these different requirements depending on the state you're in around like what other types of permissions you need to get. And you should be able to visit your Secretary of State's office to find out what those things are. They're like, go to their website and see what they say. And then finally, don't forget your domain names. The moment you've decided, okay, this is the name that's not going to get me sued, this is something that's going to become part of my brand, buy the domain names and get the social media handles. Do all those things right away. And you want to do those things because you don't want to get caught out here slipping. You've taken all these early steps, but when it's time to like start tweeting or posting on Instagram or whatever, maybe somebody else has beat you to the punch and gotten the social media handle. And with the domain names, the same thing. You want brand consistency, so don't forget your domain names. So I hope this was helpful. This is a conversation I'm having on Clubhouse. If you're on Clubhouse, you can find me at Shontavia JESQ. Make sure you look me up there. Make sure you follow me. I'm Shontavia Johnson. And I have created this podcast made for entrepreneurship, specifically to summarize the conversations I'm having on Clubhouse. Thanks for watching. Or thanks for listening.